Yeah, welcome back to the No Stay Project. I'm your host, Mark Stevens, markstevens.net. It's M-A-R-C, Stevens with a V. You can listen to the show there. Also, you can, Calvin, I want to thank Calvin for all the work he's done on the archives. He's got, on the forum, he's got a link for the local affiliates. You can also go to lrn.fm. And there is a list there of local affiliates that carry this show and the LRN programming. So you want to check it out. Again, what is it? No, it's not 420 yet. We actually passed the 420 for the East Coast. I want to dedicate at least the East Coast 420 celebration to Ian Freeman of Free Talk Live for all the work that he's put into with me today so that we can get phones. And speaking, of the phones, all this work we did, and my phone lines are dead, JT.
You're kidding me. No one's calling in?
Well, we had David in, and he kind of dropped off. I don't know. Maybe he had to go, but he was patient. He was on the line for a while, so maybe he'll call back. But we got 218-632-9399. That's 218-632-9399. And I'll get back to what we were talking about. So here we're at this hearing, and again, I was representing him. I was representing the client, but
right.
I was all, I don't think you at the state level unless you're in Oregon and there's something special about Oregon, you don't have to be an attorney or a member of a bar association in order to assist people or represent them in these state tax hearings and whatnot. So we get there and we're trying to get the ground rules. He agrees readily, and he actually was a decent guy. Yeah, so you'll hear that on the recording. He wasn't some overbearing jerk like the ones that arrested Pete on Monday. But he answered yes, that if there was no evidence or they couldn't verify their assessment, then he would be able to zero it out and show that it was completely incorrect, and that would be it.
That sounds promising.
Yeah, so I was like, oh, okay, this is a good thing. This is good. So we didn't have to spend, half a day, going through that. So, because, he gave his thing out, he could do, where it was completely incorrect and zero it out and thank you, have a nice day, that's it. And then he said there was where it could be partially correct and, they could have an agreement to waive penalties and whatnot, and then it was correct as stated. So, he said 95% of them they did in the middle where it was partially correct. So, we're going through this. Then the agent actually went under oath. They put her under oath, which was, again, when the tax situation, that's almost unheard of.
It's huge too. It's great.
Yeah, get them on there. Because if you really want to shut up an IRS agent or a tax agent and say, "Oh, you think I owe taxes? Could you put that in an affidavit for me? Could you just put it on the penalty of perjury there? Yeah, I'll hold my breath while I wait for that." So they don't like that. They don't like that one bit. So we get the agent under oath, and the problem you got to hear this. What I'm going to say is going to sound like it's outlandish, but if you've been following the show and you've been following my material and on the website, you're going to believe me. But new people, you got to hear for yourself, JT. You can't make this crap up. She's under oath, and she admits that there are no witnesses with personal first-hand knowledge my client's a taxpayer or has taxable income, including and she's including herself there.
Well, that's it. Okay, I guess we can go now, right?
I guess we're done. But it gets even better. She also admits she's got nothing for most of the years in question. Nothing. And she's trying to base it off of a previous year. I said, but yes, but you do agree you're really not basing it on anything for the year in question. You have nothing. No evidence, no witnesses, nothing. And she agreed. Again, this is on the penalty of perjury, everybody. I want everyone to understand this is serious stuff, right?
You would think they'd be held to, especially in a situation like that they would be held to account. Yeah,
but it gets even better. So we go through this whole thing about them not having any evidence for those years in question, and so now I turn my attention to the evidence. Now, remember, we've already got her on record that about the evidence that that nobody could determine that the income was taxable. There's no evidence. Nobody could do it. So she restates that she's not. She actually says she's not qualified to say whether the income is taxable. Right?
Wow.
Then she had to say something that I had to get her to confirm because I never heard this before. She actually agrees that, or admits, she wasn't authorized to do the assessment.
You're kidding. So she admitted under oath that she's not authorized to do the assessment, let alone having any first-hand knowledge of the facts.
Yeah. Yeah. So I said, so basically I'm trying to paraphrase what I said here because I haven't listened to the recording yet. I haven't had an opportunity. I said, wait a minute. You're going to have to say this again for me just to confirm so I'm hearing this right. Did you really just admit that you weren't qualified? And yeah.
Wow.
Yeah,
So it ends right there. I mean, I would think that the gentleman that said that, if can be shown that there's no evidence and no witnesses, I'll zero it out. So it's zeroed out then, right?
Well, that's what I moved to do. I said, well, since she's not qualified and she wasn't authorized, the whole thing is incorrect and should be zeroed out. And he said he wouldn't do that. He was not going to make a determination on the weight of her testimony. I said, but she admitted. Now remember, we're not arguing back and forth it wasn't nasty. I don't want to give that impression. But I said she was the one that testified she wasn't qualified.
And right, and the amount is predicated on her actions, and she just admitted to you she's not qualified to take those actions. What else is there to consider?
Yeah, hello. So he said he was not going to make a determination during the hearing as far as what her qualification, what weight, if any, should be given to her testimony. And so so we've got that. So we got a lot going for us. I'm pretty confident in this one. I'm very happy with this one. And what he did was I got him actually, as nice as he was, I got him to stop the cross-examination. And what I did was I was sticking strictly with the facts. I said, can you prove the income is taxable using just the facts and no citations to the law? And he would not allow an answer. He says, I'm going to stop this. I said, why? He said, well, because we've already gone so much time. I understand.
Because it's points. Damning to my case.
Yeah. Well, what he was trying to say was that, without using the word, what I was doing at this point was cumulative, that I had already made my case. I didn't have to go any further, that the witness was already not qualified, and cross-examination from that point was not really necessary. I mean,
if he's going to take the position that he's not going to predicate his decision on the weight of the witness's testimony, I think you do need to pile on.
Yeah, especially because that brings me to why I think, and the client jumped in and he jumped in as well. I think this is an example of why I can't get a fair trial from you or a fair hearing. I went through, because that was the stopping point, but he read through the points that we had made, our objection, and he seemed to be, fair. So, but that's it. I got a very good feeling about this. And I think the client was right on the money when he made his objection and pointed out that the hearing officer was not being fair with us anymore. When at the beginning, what I did was I went through the typical line of questioning that I do in court, where I asked the hearing officer if my client was entitled to a fair trial, and he said, well, yeah. And then, I asked about the conflict of interest, and he said no, he could. I believe he said no, he couldn't. But I'm a little sketchy on that. I may have just jumped to who do you represent here, and he said that he represented the comptrollers. And I said, well, wait a minute, but the comptrollers are the other party to this proceeding. Wouldn't that be a conflict of interest if you, as the hearing officer, if you're representing a party like the comptroller? And he agreed. He said yes.
Well, so exit stage left for him then, yeah?
Well, you would think. And he thought that he could still provide a fair trial, a fair hearing. And he said, well, and he made a notation on the objection. We did object. Now, we proceeded anyway because I think we got some valuable information. I would imagine in some circumstances like court and whatnot, if you get the judge to admit it's a conflict of interest, you probably shouldn't proceed any further. Unless you're pretty confident that you can get that witness declared incompetent and, move to have the testimony stricken. So he says, you can always appeal my decision. If you don't think it's fair, you can appeal it to the tax court. I said, yeah, but who pays the tax court? They're paid by this, from the same people who, in this proceeding, the comptroller's office, who's trying to take my client's money. If they take my client's money, it's going to go to pay the judge.
Exactly. So there's another conflict of interest. What do you have to say for himself then?
Well, what he did was he pointed out that he said that he believes he was trying to confirm that I thought there would be a conflict of interest all the way up to the Supreme Court. I said, well, yeah.
Well, yeah, factually, yeah.
Absolutely. I think we've established that. Well, we'll get this and more. We'll take your calls the next hour. Number is 218-632-9399. That's 218-632-9399. Don't go away. We'll be back in just a few moments.